Hello and welcome. My name is Mark Blatstein, the physician founder of Physician Pre-Sentence Report Service. Today, I'm going to discuss for a little bit Sam Bankman-Fried, the Bitcoin mogul who took FTX from a mega company to bankruptcy. And while this is 7 months old, as it says, pretty much everything that he's done, he's hurt himself. And I'm sure it started long before Mr. Bankman had his bail revoked and he was remanded to a federal detention center. But witness tampering doesn't really go very far. And even though you go to trial and most on the federal side of these trials lose, you really don't want to anger the court and the judge because eventually you're going to come back to this same judge to get some sort of leniency. So, briefly rolling through time and some news articles, he's been fighting for his survival. He was convicted on crypto bank fraud. Now all of a sudden he wants a lighter sentence. But how do you go back to the judge and ask for a lighter sentence? When you've angered him and really done nothing to help yourself. And sometimes it comes down to surrounding yourself with enablers and attorneys that are not going to sit you down and tell you that this is not the best way to defend yourself. We'll go to the Wall Street Journal, where they're going to be calling for a much shorter sentence. I haven't seen much in the news regarding autism for him. It probably would have been a good place to start before he started making news that angered the stakeholders or everyone else that was going to be responsible for giving him a lengthy sentence or a sentence that is not that lengthy. And this also goes to the probation officer who writes his pre-sentence report. Now says Sam Bankman-Fried's lawyer says the sentencing of 100 years would be grotesque and barbaric. But there was nothing that Sam Bankman-Fried did throughout his time to help him or to help himself. And so trying to get this 100-year sentence changed is really going to not be that simple. So that brings me to the sentencing memorandum for Samuel Bankman-Fried. And I'm not going to go into it in detail, and I'm not an attorney, but I'm just going to highlight some things that I go ahead and review with those that I work with to help them get the best or lowest possible sentence. Doesn't always work. No one can guarantee you what the judge can do. But in this particular case with Mr. Fried, he's done everything he can to hurt himself. And so we're going to go down to some of the things that the attorneys wrote. They wrote about his early life, going to college, Alameda research, his philosophy and philanthropy. He's not motivated by greed. If I could make this larger, I would do it. And actually, let's see. Um, that's too large. Okay. So his early life is, his upbringing, his college time on Wall Street, out with Alameda Research. The fact that he's not motivated by greed, he has a lot of philosophy, he has a lot of philanthropy. He's a caring person for others. Work ethic shows he has remorse. All of this is good, Sam's condition. But the problem is that the lawyer shouldn't be the one writing this. This should be in the form of a narrative that apparently, unless I'm mistaken, which is possible, that Mr. Fried never wrote. And so having all of this written by the attorney in the sentencing memorandum is really anticlimactic because judges understand that the probation officer, as an officer of the court, is really a neutral party. But unfortunately, due to Mr. Fried's notoriety, he was definitely in the public eye. Judges also understand that the prosecutor wants to get, for the most part, another notch in his belt because they may want to move on to politics, to become a white collar criminal defense attorney. They know the Department of Justice wants prison time. The one thing that judges don't know, for most of us, is that they want to know the person. They want to know who Sam Bankman-Fried is. And unfortunately, the the opinion that he's left with the same judge who's going to sentence him because of his witness tampering is not a great one. And yet, he still could have come back and written a narrative, but instead, because his attorney has written his early life, his time through college, Alameda research, not motivated by greed, judges know that attorneys are paid so that their client will get the best possible deal they could get, the lowest sentence, the less amount of time in prison, maybe no prison. But the fact that all of this, he was not motivated by greed, cares for other people, has a work ethic, shows remorse. I don't know that this is going to carry enough weight to sway the judge into giving some sort of a leniency to Mr. Fried. And so while they have written this 90 some odd pages memorandum to the court before sentencing, I really don't know if this is going to go ahead and sway the judge at all, because judges will usually be swayed by by reading, the narrative, or having the narrative be prepared so that Mr. Fried or the defendant can talk to the judge at sentencing. And I don't know that re-looking at all of this, if Sam Bankman-Fried is going to be in the correct mindset to understand that he accepts responsibility to his company. When I was in practice, I'm the person that's responsible. I was convicted of a felony in 2006. I'm grateful that in 2010 I was be able to get my license reinstated in full to practice. But Mr. Fried hasn't done any of this. And so for him to be able to accept responsibility, I don't see it here, and there's no narrative. I don't know if he's prepared to do that to the judge, understanding that there are victims and that he has remorse or feels bad for those that he's hurt, which are a lot of individuals. The judge may look at this, and this is nice and put together in a very formal way, but in the end, judges want to talk to the person. They want to talk to you and understand that, you accept responsibility for what you did. You have remorse for the victims you harmed. And do you have a plan to make them whole? And I don't know that this accomplishes any of that. It's a very good, well put together sentencing memorandum, but all the judge knows at this point in time is that they had to remand him for witness tampering, and they really haven't gotten to know the individual. And there's nothing that the attorneys can do through this memorandum to solve that problem. And when the judge talks to Mr. Fried at sentencing, is he going to be prepared to have a good allocution or conversation with the judge and have him believe that I did wrong, I accept responsibility, there are victims, there's multi-billions of dollars or millions of dollars at stake, and a lot of people have gotten hurt. So if you're looking at this, and I appreciate you taking the time to listen to this YouTube, understand that you want to do everything almost the opposite of what Mr. Fried has done. Your attorney sentencing memorandum does not take the place of you before your pre-sentence interview having a internal conversation with yourself and understanding that you have to accept responsibility for what you've done. You have to believe it. You have to understand that there are victims and you have remorse for the victims that you've harmed. And all of this has to be believable. And then some sort of plan. He should not expect 100 years is a long time for prison. I don't know if he'll get that, but he's done nothing, at least from what I can see, to change the judge's mind, because he's a guy in his 30s. He's a very smart fellow, and he could have done something to put his best foot forward rather than having his attorneys do that through this sentencing memorandum. I appreciate you taking the time to listen. I hope you have a great day and a safe day, and stay tuned for our next conversation. Stay safe.